I will call this hearing of the Judiciary, Finance, and Civil Law Committee to order. Today is March 19th, 2024. We do have a quorum. First item on the agenda is the minutes from March 15th. Representative Finke, will you move the minutes of March 15th?
Madam Chair, I move the minutes.
All right. Any discussion to the minutes? All those in favor, please say aye. Aye. Opposed? Minutes are approved. We have a very full agenda, so all the testifiers have been told how much time they have, and hopefully we're going to have a productive day. Welcome, Representative Bierman. You are first up. I will move to refer House File 4853 to the Health, Finance, and Policy Committee. Welcome to the committee. Please tell us about your bill.
Thank you, Madam Chair. Thank you, committee members, for hearing House File 4853. We will focus on the issues pertaining to judiciary, but a little explainer about the bill will be helpful. HMOs were invented in Minnesota in 1973. The pledge of the nonprofit HMO has always been to exist as a charitable organization for the healthcare benefit of Minnesotans. These entities and how we regulate them in a complex and evolving healthcare marketplace have clear financial implications for our citizens. This bill addresses the issue of conversions of nonprofit health maintenance organizations. A conversion is the transfer of all or a substantial portion of a nonprofit health maintenance organization business or assets to a for-profit entity. Conversions in other states, unprepared for such transitions, saw charitable assets removed from public benefit after years of public investment, making millions of dollars for the executives and doing little for the people in their states. This bill creates robust safeguards around conversions for the public interest, including a transparent public process, a full and fair market value assessment of the public benefit assets to be preserved for the public good. The bill also assigns the Attorney General as the current protector of charitable assets in Minnesota presently to ensure that these public assets from conversions are utilized as designated to advance the future healthcare interests of Minnesotans. The Minnesota Department of Health is the regulator of Minnesota's HMOs, but they receive far less information and oversight than the Department of Commerce has over health insurers. This bill updates the sight lines to regulate both nonprofit and the new for-profit HMOs allowed to operate in Minnesota since 2017. The articles that pertain to this committee's jurisdiction, Article 1 takes a small subset of the existing statutes, those that govern financial transaction reporting for insurers, and says that HMOs are also subject to them. Article 1, Subdivision 1A is regards to confidentiality. Under current law, these data are classified as non-public for insurers, and the same classification would now apply to transactions involving HMOs. Article 1, Subdivision 1A, also Subdivision 7 speaks to the jurisdiction of Minnesota courts with regard to violations of this section of statute. Article 2, Section 5, Subdivision 2, the AG already can pursue equitable relief if an entity violates Minnesota nonprofit or antitrust laws. This section adds to the ability to sue if a transaction violates public interest. This section allows MDH to share non-public information with the AGO to aid in their investigation of conversion transactions, with a requirement that AGO maintains the data with the same classifications. And Article 2, Section 5, Subdivision 3, MDH can share data with the AGO consistent with the terms of the DPA, the Data Practices Act. Article 2, Section 6, data provided by HMOs is classified as AGO data under the DPA. So, Madam Chair, this is it in a nutshell. I do not have any testifiers today, but I do have I can take questions, and if I need some help, we have the Attorney General's office and the Minnesota Department of Health here to go take a deeper dive.
Hopefully not. Are there any members of the public wishing to testify on this bill? All right, not seeing any, we'll move on to member discussion. All right. Representative Carroll.
Thank you, Chair, and thank you, Representative Bierman, for bringing this bill. I think it's needed. I used to serve as general counsel to Metropolitan Health Plan, Hennepin County Safety Net Health Plan, and I took pride when I went to national conferences that we are the only state that required health plans to be nonprofit. I was shocked and disappointed when the law was changed, so thank you for doing this.
All right. Representative Niska.
Thank you, Madam Chair. And Representative Bierman, I'm curious about the language about the Attorney General's powers referenced on line 8.25, saying that the Attorney General has the powers in section 8.31. I don't see anything in here that references the private right of action in subdivision 3A. Am I missing that? And is there some language here that deals with the reference to a private right of action in 8.31 subdivision 3A?
Representative Bierman.
Madam Chair, I think I'll ask the AG's office to come down and respond to that, and we'll have them weigh in here. Thank you.
Please introduce yourself and proceed.
Good morning, Madam Chair and Representatives. I'm Erin Conti. I'm with the Minnesota Attorney General's Office. Madam Chair and Representative Niska, there's not a provision about a private right of action. Within the remedies section in Article 2, it talks about that the Attorney General may bring suit to pursue equitable remedies, and it adds as a cause of action within that we may sue if a transaction is not within the public interest.
Representative Niska.
Thank you, Madam Chair, and I appreciate that answer, Ms. Conti. I guess I'm still concerned about to what degree 8.31 is being, or this statute is being brought within the scope of 8.31, because as you know, 8.31 has in subdivision 3A a sort of broad private right of action that applies to anything that, any statute that comes within the scope of 8.31 subdivision 1. And so I'm just trying to understand whether that's sort of an intended consequence of this bill, that this is creating some sort of new 8.31 subdivision 3A private, potential for private suits, or whether whether I'm misunderstanding the reference to 8.31 here.
Understood. Madam Chair.
Yep.
Niska.
Go ahead.
Apologies. So it is not intended to create a new private right of action. 831 is, as you know, very frequently thrown in as kind of a catch-all for the Attorney General's powers to get a CID if additional follow-up is, or issue a CID if civil investigative demand, if additional information is needed, and to kind of use those other basic investigative tools. That's the reason for the citation.
Representative Niska.
Thank you, Madam Chair, and I appreciate that answer. I guess I'm very concerned then about the way this sentence reads on 8.25. The Attorney General has the powers in section 8.31. It seems to be either that means nothing and 8.31 already applies to all of this stuff, or this seems to be sort of expressing our sense as the legislature that this bill, that this new provision that we're creating is something that falls within 8.31 subdivision 1. And 8.31 subdivision 1, if any deceptive or any of the many different consumer fraud or consumer protection statutes that are referenced in 8.31 subdivision 1, in 8.31 subdivision 3A, there is a explicit private right of action that references anything that's within the scope of 8.31 subdivision 1. So either this sentence is unnecessary, or we are creating a new private right of action unless there's some clarifying language added to it. So I hope that will be taken care of. Yeah, if you have comments on that, I do have some other questions as well about the bill.
Representative Niska, this was already in Commerce. I know we had a chance to talk about it there. Are you intending to create a separate right of action?
Madam Chair, Representative Niska, no. And again, the reason this language is there is it's carrying over the Attorney General's obligations to protect nonprofit assets. Those are already established and codified in other spaces in law. We did not want to create ambiguity around these conversion transactions. We are trying to ensure that the existing processes are still respected while these additional sightlines are being provided to the commissioners.
All right. Anything else, Representative Niska?
Yeah, thank you, Madam Chair. And again, this is the committee where we deal with private causes of action. I think that there's some, I guess I missed the amendment deadline to fix this problem, but I do hope that the author and the Attorney General's office will take another look at how this language is drafted and what the implications of it are if a private right of action is not intended. I guess I'm just curious more generally what the purpose of this bill is and how it interacts with our legalization of for-profit HMOs. Is this just a way to kind of chip away at that, Representative Bierman?
Madam Chair?
Representative Bierman, and remember, this is going to health next, so there is time for you to come up with an amendment. Representative Bierman.
Thank you. So first off, this bill assumes that the nonprofit and for-profit will coexist in the state of Minnesota as it is right now. So this is assuming that, but we are looking at and asked for help from last year's bill about the standards and guidelines of HMOs, which have not been updated in decades. And we need to address this because when they first came out, HMOs, there were no for-profit. So both need updating, and that was the purpose of the study that MDH did. They came out with their preliminary report, which came out on January 15th. It's available to all of you. I encourage you to read it. It's a short read. It's like 75 pages, but it is very good, and it sort of lays out the issues and looks to other states, too, to just see the best practices. So that's where this is coming from. We are adopting some of those best practices in an initial phase of this session, and that's what this bill reflects.
All right. Representative Johnson.
Chair Beckerfin, Representative Bierman. I'm just wondering, since 2017, I'm not sure how many nonprofit HMOs we've had, but that's over 6 years ago, pushing 7, since we allowed private HMOs to start in Minnesota. Are you aware of any nonprofit HMOs converting to private in Minnesota yet?
Representative Bierman.
Madam Chair, Representative Johnson, there's been a conversion moratorium in Minnesota for these years. It's been renewed a couple times, and it presently is in play still. So it actually had it would have opened up last July had we not passed an extension of that. So we have kept the lid on that at this time. But there's other things to consider here in the complex world of healthcare and all of the entities that are involved, whether they're domiciled here in Minnesota or out of state. There's no real regulation or guidelines on that. They are complex enterprises with multiple for-profit and nonprofit portions, which at times they can transfer money from one to the next. And so we need to have better sightlines on what's going on there to protect the public interest, which has been building these HMOs all of these years with public dollars, public taxpayer dollars, and certain tax benefits.
All right. Representative Johnson.
Chair Beckerfin, Representative Bierman. I know I've talked to a few of the different HMOs companies, and they are concerned that in the long run, a bill like this is actually going to increase healthcare costs because increased insurance premiums and stuff like that. So I do have concern on this, the way this is written right now. I think we need to look into it more before we go too far down the pipeline, because insurance rates and stuff already in Minnesota are out of sight. Most people can't afford them. If they can afford them, they cannot afford the deductibles that they have to pay, and I'm concerned it's going to make things go backwards farther.
All right. Closing comments. Representative
Thank you,
Bierman.
Madam Chair. And just closing comments, I share those concerns about the high cost of healthcare, and this is just one piece of that work that we all need to pay attention to and address. So thank you, Madam Chair.
All right, with that, I will renew my motion to refer House File 4853 to the Health, Finance, and Policy Committee. All those in favor, please say aye. Aye. Opposed?
No.
Motion prevails. Next up, we've got Representative Freiberg. Representative Freiberg, I will move to refer House File 3410 to Ways and Means. And for the purposes of this committee, we're primarily looking at subdivision, Section 1, Subdivision 6. But Representative Freiberg, welcome to the committee. Please tell us about your bill.
Thank you. Is the motion to Ways and Means or the General Register? My understanding is the costs were removed in the amendment in agriculture.
It's your bill, Representative Freiberg. Where would you like me to move it?
I believe we checked with House Fiscal and it was okay to go to the General
All right,
Register.
I will amend my motion. The House File 3410 be referred to the General Register.
Thank you, Madam Chair. So, thank you, Chair and members of the committee. This bipartisan bill was brought to me by the Animal Humane Society, Minnesota's largest nonprofit companion and animal welfare organization. The Humane Society operates 3 shelters in the Twin Cities area, including one in the district I represent. And I know that many people in this room, including me, have adopted pets from one of those shelters. We have shared the language of this bill with numerous stakeholders, including the Minnesota Veterinary Medical Association, which is neutral on the bill. This bill is simply about transparency. In Minnesota, kennels, shelters like the Animal Humane Society, and state-licensed commercial breeders are required to be licensed and inspected. Under current law, the inspection reports and other data for commercial breeders are classified as private under the Data Practices Act, so consumers cannot see the inspection reports even if they plan to purchase pets from a breeder. The same reports for kennels and shelters are already public data. People want to access information they can trust, whether they are choosing a restaurant, hairstylist, or a dog and cat breeder. There's a chart in the packets showing that inspection data for most state licensing boards in Minnesota are public, and most boards post the information online. My bill treats dog and cat breeders like other regulated businesses. With that, I'd like to have Kim LeBeau from the Animal Humane Society speak next.
All right. Welcome to the committee. Please introduce yourself and go ahead with your testimony.
Thank you, Chair Becker-Finn and committee members. I am Kim LeBeau with Animal Humane Society. Thank you for hearing this bill today. Each year, Animal Humane Society adopts more than 12,000 pets from our 3 metro area shelters. And as an animal shelter, we are licensed and inspected by the Board of Animal Health. By law, licensing and inspection data for Animal Humane Society and all of Minnesota's nonprofit shelters and other regulated businesses is public data. In contrast, the same information on state-licensed dog and cat breeding businesses has been classified as private data. So as a result, I can find out more about my state-licensed hair salon than I can about the breeder who raised my puppy. This bill makes breeder data public and holds commercial breeders to the same transparency standard as nonprofit shelters, dog and cat dealers, and other regulated businesses. This applies to about 107 state-licensed commercial dog and cat breeders defined by law as breeders with 10 or more adult animals that produce 5 or more litters per year. It does not apply to smaller breeders who are not required to be licensed. And while Animal Humane Society encourages people to adopt, we also support responsible breeders. And this position has been stated on our website for the past 13 years. And as part of this position statement, we encourage people to do their research before spending thousands of dollars to ensure they are purchasing from a reputable breeder. This bill will allow people to do their homework so they know if a puppy was raised with 5 or 500 dogs, whether a breeder is a repeat offender, or if their license was revoked. So we urge you to pass this bill because it will ensure consumers have access to critical information before they make a significant financial and emotional investment in a pet. Thank you.
All right, thank you for your testimony. Are there any other members of the public wishing to testify on this bill? Not seeing any, we'll move on to member discussion. Representative Scott.
Thank you, Chair Becker-Finn, and to the testifier. My question is when someone adopts from one of your shelters, is there information about that pet and how they were raised?
Any
Ms.
information?
LeBeau.
Thank you, Chair. Any information related to the licensing and inspection process of Animal Humane Society as a shelter is public data.
Representative Scott.
Thanks, Madam Chair. Well, so I'm a little, well, that answer is not really answering my question. You want the breeders to give all this information about how the puppy, what kind of environment it was raised in, but you probably, the animal shelters don't know really when they get an animal, not all the time anyway, you're not always going to know what kind of environment your dogs or cats were raised in. Is that an accurate statement?
Ms. LeBeau.
Thank you for the question. So this bill is to really reveal kind of the data related to the inspection process run by the Board of Animal Health. So allow people to know how many animals a breeder has, so whether they have 800 dogs or if they have 50 dogs. Animal population data related to nonprofit shelters is also public data related to the inspection process. When we're inspected by the Board of Animal Health, the conditions in which the animals are housed are part of that inspection process. So they look at the conditions within the shelter and we're graded just like a commercial breeder is related to, is there adequate food, is there adequate water, et cetera. So those are the standards that would be, in that report would be public.
Representative Freiberg.
Yeah, thank you. And I don't know if this also answers your question, Representative Scott, but it's kind of in the nature of a shelter to not always know the exact background of an animal. I've adopted 4 cats from the Animal Humane Society over the last 15 years or so. And, you know, I knew going in, like, we found, they would say, we found this cat out, you know, outside when it was approximately 1 year old based on the condition of its teeth. So that's, you know, not something that's always possible to be known even. All this bill does is require that the same information about the number of animals that's currently known for shelters and kennels be available to the public for breeders as well.
Follow-up, Representative Scott.
Yeah, thank you, Madam Chair. Isn't it accurate that a person right now that's seeking to purchase a dog, and don't get me wrong here, we're on our 3rd dog. I mean, I love dogs. Cats, but
I won't hold that against you, Representative Scott.
Don't worry, I'm a dog person, Representative Scott.
see, on the
Don't
chair.
get started with Representative Moeller, though.
Oh, okay, all right. So it's already available that these inspections are done, and it's on it's for the public's consumption, whether or not that breeder is in good standing with the folks that did the inspection, the Board of Animal Health. It's already stated that they're in good standing. If the inspection went horribly wrong, that's not what it would say. It would say, you know, this breeder is not in good standing. Is that an accurate statement to either the testifier or the author?
Ms. LeBeau.
So we do have summary data from the Board of Animal Health's annual report that there were 47 violations recorded for animal breeders over the last 5 years. But the problem is we don't know what the nature of those violations were. And, you know, it would be have to be pretty severe for the license to be revoked. So it's just making sure that there's the same level of transparency that we have for other licensed businesses or entities, where if you have a violation, that's public information as to what the nature of the violation was.
Representative Scott.
No further questions, Madam Chair.
All right. Closing comments, Representative Freiberg.
Thank you, Madam Chair, members of the committee. This is a good bill that just makes public information to various licensed entities consistent. So I would encourage members to support it. And thank you for your time.
All right. With that, I will renew my motion to refer House File 3410 to the General Register. All those in favor, please say aye. Aye. Opposed?
No.
Motion prevails. Thank you, Representative Freiberg. Representative Jordan? All right, I will move to re-refer House File 3577 to Ways and Means. Representative Jordan, I understand you have an A4 amendment. Would you like me to move that as well?
Yes, Madam Chair.
All right, I move the A4 amendment. Can you tell us real briefly what the A4 does?
Yes, Madam Chair. This amendment is cleanup and further harmonizes this bill with other states that have existing and Canadian provinces that have passed similar laws. It also adds to the exemption list medical devices and drugs, pesticides and insecticides, and animal medicines, big theme today, from the exempt materials. It also exempts newspapers with circulations of less than 20,000, and it edits the statewide recycling list, which includes specific collection requirements based on population to account for differences between the metro and greater Minnesota.
All right, any discussion to the A4? All those in favor, please say aye.
Aye.
Aye. Opposed? Motion prevails. The amendment is adopted. Representative Jordan, please tell us about your bill.
Thank you, Madam Chair. And thank you for moving my bill. House File 3577 is a bill to deal with our waste problem, because we have one in Minnesota. And 40% of our waste comes from packaging. This percentage of our waste will continue to grow as we have more and more of an e-commerce economy. And currently, we, taxpayers and residents, are responsible for the cost of a product's end life and the packaging that surrounds it, as we pay taxes to our local governments and fees to deal with our waste. And much of what actually could be recycled is put in a landfill or burned in incinerators. This is also a public health concern. Incinerating and landfilling packaging is terrible for our environment, our water, our soil, and our bodies. The average American consumes a credit card worth of plastic each week. Microplastics have been found in breast milk, cord blood, and placenta. There is runoff from these plastics into our water and soil from landfills, and it also gets into our lungs as we incinerate trash and breathe in the air that is all around us. And so this bill is the solution. We need to generate less waste and deal with what waste we produce more effectively. And this bill does both. There are goals on page 15 of your bill, and the idea behind this bill is that the producers of the packaging pay. This forms the Producer Responsibility Organization, or the PRO, and I'm just going to keep saying PRO because it's too early for me to keep saying Producer Responsibility Organization over and over again. A needs assessment determines the PRO's activities, and this is updated every 5 years. The needs assessment is generated by producers, waste haulers, environmental organizations, and the MPCA. The MPCA also holds the PRO accountable for reaching the goals described in the needs assessment. And so there are two sections of this bill that are in the committee's purview. The bill has already been examined in the Environment Committee, the State Government Committee, and the Commerce Committee. Section 18, lines 33.19 to 33.24 is an anti-competitive conduct section, and then section 22, which is enforcement, which is lines 34.13 to 34.30, is the enforcement section. Both of these are standard boilerplate enforcement language from the MPCA, consistent with other product stewardship laws on the books. And Madam Chair, that's the bill, and here to say more is Kurt Kudelka from the MPCA.
All right, welcome to the committee. Please introduce yourself and proceed.
Thank you, Chair and committee members. For the record, my name is Kurt Kudelka, with the Assistant Commissioner with the Minnesota Pollution Control Agency. I want to thank Representative Jordan for championing this important bill that the MPCA supports, and we'll continue to work with her as it moves through the process. Collectively, Minnesota has a waste problem to the tune of 6.1 million tons per year, and that number is only expected to grow. Right now, we only recycle about 45% of it, which means over half of it is still going to a landfill or waste energy facilities. These have negative environmental, human health, and economic impacts. The impacts of the life cycle of the products we produce and dispose of are enormous. To illustrate the benefits of waste reduction, reuse, recycling, and composting, Minnesota saves the equivalent of 4.6 million metric tons of carbon dioxide due to these activities each year. That's roughly the annual emissions of 970,000 passenger vehicles. Reducing, reusing, and recycling waste reduces greenhouse gases, while landfilling increases them. There are also lost economic benefits. We throw away about 1 million tons of recyclable materials each year. That value of the material is estimated to be $143 million going into a landfill or burned up. New and expanded businesses could create over 15,000 jobs with those materials. We have a ways to go in order to achieve the goals set by you, the legislature, and the Waste Management Act. And this legislation provides Minnesota with a system and resources to reach those goals for waste packaging. The MPCA's 2022 Sustainable Materials and Solid Waste Policy Report to the legislature recommends the establishment of a product stewardship program for packaging, just like this bill. There's no need to wait for another report on it. The product stewardship model, which this legislation utilizes, is a public-private partnership that is used in many locations across the nation and for products in Minnesota. The private side of the equation comes from the form of a PRO, or product stewardship organization. On behalf of producers, they draft and implement a plan to prevent waste in the first place through waste reduction and reuse efforts, and then, if not possible, fund for a recycling stream to reclaim materials and properly manage them. The anti-competitive language in the bill is similar to provisions enacted by the legislature when passing the Battery Product Stewardship Bill in 1991, the Electronics Waste Product Stewardship Program in 2007, and the Paint Product Stewardship Program in 2013. Specific to the collection of waste and recyclables, as envisioned in this bill, similar language was given to local governments in 1989 for a collection of these materials. This is something the legislature has done over and over, and we have not heard of any complaints or problems stemming from these provisions in Minnesota. In addition, as mentioned, the enforcement authorities are things that are already implemented by the agency and are similar to what we've done in other areas. On the public side of that partnership, the MPCA is charged with the oversight of the PRO's plans through the approval and denial of the plan and setting other requirements based by criteria outlined in the bill by the legislature. In addition, the agency oversees the implementation of the statewide performance metrics for waste prevention, reuse, and recycling. It's why it's important the bill contains strong provisions to provide the oversight of the PRO on key issues such as the statewide performance requirements. Thank you, Chair and Committee, for your time today.
Great, thank you. We do have a couple public testifiers signed up. I have Peter Glessing and Amber Backus. If Amber Backus is here, if you could come on up to one of these chairs so we're ready to go, that'd be great. Thank you. Welcome to the committee. Please introduce yourself and proceed.
Good morning, Madam Chair and members. My name is Peter Glessing, and I'm the Senior Director of Policy and Advocacy for Medical Alley. Medical Alley is still reviewing the scope of the amendment of the A4 amendment under lines 1.10 through 1.12 pertaining to the exemption for medical devices and drugs, given that it was posted about 9:45 a.m. yesterday. With that said, we believe this amendment is a significant step in the right direction toward addressing many of our concerns about access to life-saving medical devices and drugs that we've expressed in previous committees. We are grateful to Representative Jordan for incorporating this language into House File 3577. As we move forward, Medical Alley will be seeking clarity and alignment between this bill and its companion. We appreciate Representative Jordan's dialogue with Medical Alley to address our concerns. Thank you.
All right, thank you. We do have pretty typical amendment deadlines in this committee, so moves fast around here. Welcome to the committee. Please introduce yourself and proceed.
Thank you, Madam Chair. Members, my name is Amber Backus with United Strategies, and I'm here on behalf of the National Waste Recycling Association Minnesota chapter and the member companies that have generated over 17,000 jobs and provide collection, sorting, recycling, and disposal of waste in Minnesota. NWRA Minnesota shares the goal of Representative Jordan to reduce waste and increase recycling. Our companies have been an integral part of Minnesota's nation-leading recycling rates, but under the bill will no longer have control over the recycling portion of their businesses. The bill empowers brand manufacturers through the producer responsibility organizations, which is a mouthful, or the PRO, to establish stewardship plans, and these plans decide how NWRA members would be reimbursed for providing recycling services, what the reimbursement rates would be, and the terms and conditions for the contract. And this can be done in an anti-competitive way since Section 18 of the bill explicitly authorizes the PRO to engage in conduct making it, quote, immune from liability under state laws relating to antitrust, restraint of trade, and unfair trade practices, unquote, when planning and implementing collection and recycling systems. And I would like to just quickly respond to Mr. Kadolko's comments. While this has been the standard for other stewardship programs, those were newer industries, not developed ones, where this PRO is going to be having oversight. So needless to say, this gives NWRA members great heartburn. They want to be able to protect their existing businesses and relationships and be able to compete for new business and opportunities, not have the pro fence them out. Conversely, the bill makes recycling companies vulnerable to anti-competitive claims against them, since there are no protections for the recycling companies, or service providers as they are referred to in the bill, who are required by law to implement the stewardship plans dictated by the pro. And this is highlighted on page 3 of the legal memo in your packet from NWRA Counsel. Lastly, the recycling companies have limited recourse to challenge the policies set forward by the pro, who is delegated powers akin to rulemaking authority without the due process protections afforded by the Minnesota Administrative Procedures Act. The need for adequate due process through rulemaking is especially acute here, since House File 3577 imposes $25,000 per day penalties for first-time violators of stewardship plans, as seen in Section 22B. Okay.
Please wrap up.
I can wrap it up, yeah. So we do have concerns about this non-delegation of authority to the pro, and we hope to continue working on these issues as our concerns about the pro's oversight have not been granted to date, and I thank you for your time.
Yeah, thank you. Are there any other members of the public wishing to testify on this bill? Yep, come on up. If there's anybody else, now is your chance. All right. Welcome to the committee. As people who signed up ahead of time, were told they have 2 minutes, so you'll have 2 minutes, so please introduce yourself and proceed.
Madam Chair, members of the committee, my name is Julie Ketchum. I'm the Director of Government Affairs for WM Waste Management. WM provides recycling services to communities, and we process recyclable material at our Twin Cities recycling facility. I'd like to comment on the antitrust issues and conflict of interest issues in this bill. The bill is only a framework for EPR. Many of the details will be delegated to non-elected officials, including the PRO, which is a select group of brand owners, an appointed advisory board, and the MPCA. Businesses in the PRO will collaborate with one another behind closed doors, making decisions that benefit some members at the expense of their competitors who are not members of the PRO. The PRO is an exclusive organization of big brand owners. Actions by the PRO, such as apportioning recycling system costs, are decided by this exclusive group, and then members and non-members of the PRO are assessed those fees. The advisory board is appointed by the MPCA, has 2 recyclers on it that will influence decisions affecting over 300 other recyclers in the state, including reimbursement rates for our services and where new recycling facilities will be built. These 2 recyclers could benefit financially from these decisions, posing a conflict of interest. Lastly, there's no legislative oversight for the actions by the MPCA, the PRO, or the advisory board. All 4 states that have passed EPR legislation include some involvement from the legislature during program development. In Colorado, they've run into controversy over the lack of transparency and the appearance of a few large brand owners that have hired a consulting firm to decide program details for them because of their fears with the legislation. These bills affect thousands of their competitors. In Maine, there's controversy.
Please wrap up.
I will. In Maine, there's controversy over the lack of transparency with the rulemaking process. Don't defer these rules and program decisions to a handful of brand owners in the PRO and my competitors on the advisory board.
Thank you for your testimony. All right, we'll move on to member discussion. Representative Niska.
Thank you, Madam Chair. And Representative Jordan, I think there are a bunch of potential implementation legal issues with this. I think that the National Waste Recycling Association letter is pretty good on that. I was curious, though, if you could respond to the point specifically about the antitrust provisions. In their letter, or in their memo, it says, Section 18 immunizes pros from antitrust liability, but provides no protection to producers and service providers who are required by law to implement the stewardship plans developed by the pros. And given sort of the overall structural problems that have been raised here, where the pros and administrative rulemaking is really making a lot of the policy here outside of public view, I was wondering if you could respond to that point, are we opening up, especially the service providers, to some potential antitrust liability just by sort of following the results of the law that we're passing here?
Assistant Commissioner?
Chair and committee members, the previous practice has been establishing this authority for the product stewardship organization that is running the operation. So that's why it's focused on that piece. If there are other pieces that NWRA or others think are added, we'd be more than happy to look at that. But that's where the work and the collaboration is being done. Otherwise, other pieces with the service providers are contracts, just like they are set up right now between a waste hauler and the waste company and a local unit of government. Those relationships, the difference and the change there is sometimes it's who's paying the bill. There'll still be relationships between the city and the hauler. It's just that the PRO is going to be paying the bill, or instead of a direct relationship with the city, it will be with the PRO. Those one-on-one conversations with individuals are still the same way, although, we're more than happy to look at other language to help with that issue if needed, if it's suggested.
Representative Niska?
Thank you, I appreciate that. Maybe there is some more work that needs to be done that. I guess I'm concerned that a lot of the work here is still to be done, and it's going to be done outside of the legislative process. And that's, that's no way to make law in a democracy. The laws should be made here at the legislature, not down the road in some administrative rulemaking, or even worse, in a private nonprofit entity where one sector of the economy gets together and gets to make the rules and impose it on another sector of the economy. So I don't think this is the right approach for a lot of reasons, but I do hope you can figure that antitrust piece out for sure. Thanks.
Representative Scott?
Madam Chair, thank you. Yeah, I would just echo what Representative Niska was getting at, and Ms. Ketchum's testimony was very alarming. And I just think it's setting things up in an unfair manner. It's intervening in the marketplace and giving a few people on this pro organization, they are going to be self-interested. And they're competitors with the rest of the market, and here you are giving them the inside track. So I just think there's a lot of work left to be done on this. And Madam Chair, if we could have a roll call.
Sure. Anything further, Representative Scott?
Nope, that's it, thank you.
All right. Closing comments, Representative Jordan.
Thank you, Madam Chair. Members, we can't allow, what our current system of waste management is not working. Our landfills are filling up, our incinerators are at capacity, and we're bearing both the actual costs and all the external costs associated with doing nothing. This is a bill that will make sure that we can have a waste management system and increase recycling in a way that is responsive to markets, is responsive to the need, and can grow in a way that, the legislature can't. I think it's interesting that there are members here who want to grow government instead of actually empowering those who are working in this sector to work with our government to make the laws that will allow them to do their jobs. But I think this is a good bill for members, and it's a really good bill for your taxpayers, too, who are currently bearing the costs of industry as they do nothing about their packaging. And so I'm very grateful for the support and look forward to talking about this more.
All right. Seeing no further discussion, I will renew my motion to refer House File 3577 as amended to the Ways and Means Committee. The clerk will take the roll.
Chair Becker-Finn.
Aye.
Vice Chair Frazier.
Aye.
Minority Lead Scott.
No.
Representative Carroll.
Aye.
Representative Curran.
Aye.
Representative Feist.
Aye.
Representative Finke.
Yes.
Representative Frederick.
Aye.
Representative Grossel.
No.
Representative Johnson.
No.
Representative Moeller.
Aye.
Representative Niska.
No.
Representative Weens.
No.
8 ayes, 5 nays.
All right. With 8 ayes and 5 nays, the motion prevails. Thank you, Representative Jordan. Next up, we have Representative Huot. All right, Representative Huot, I will move to recommend that House File 1718 be placed on the general register. Welcome to the committee. Please tell us about your bill.
Thank you, Madam Chair, and thank you, committee members. This is a simple bill that took us a while to get here, but we're here, and it's a pathway for our railroad police officers to become Minnesota peace officers. For years, this has been worked on. Many stakeholders have been involved in this, and here we are today. I think we're only here to address a few issues of the bill and move forward. With me, I have a representative from the railroads. If that's okay, I'd like to turn it over to her.
All right. Amber Backus, please introduce yourself and proceed.
Thank you, Madam Chair. Now putting on my conductor's hat, as I am the representative for the Minnesota Regional Railroads Association and the 4 Class 1s and the regional and short line railroads that operate in Minnesota. We do appreciate Representative Huot bringing forward this bill. It's been 30-plus years in the making. It does establish a railroad police as licensed peace officers in the state under the authority of the Peace Officers and Standards, or Post Board. And I think we're here because of subdivision 9, the railroad liability provision. And we wanted to be sure that while these officers are going to be acting as any other law enforcement, the state is not on the hook for their actions. It would be the railroad companies themselves if something were to go awry. I just want to quickly point out that the Minnesota Association for Justice recently brought forward some issues with 3.28.3.29, and we're happy to strike that language, but we can do that at a later stop since we didn't have time to have an amendment prepared.
All right. I've also got Joel Carlson signed up.
It's high up today.
Yep. Welcome to the committee. Please introduce yourself and proceed.
Good morning, Madam Chair and members. Joel Carlson. I own a legal research and government affairs business here in St. Paul, and I'm here on behalf of the Minnesota Association for Justice. And I want to say, since 2008, I have finally found something that Representative Scott and I agree on. I appreciate your comment on the cats.
On the record, even.
Madam Chair and members, there are 2 spots in the bill that deal with immunities for these private employees that work for the railroad, and it is internally confused. And there is a immunity reference on page 2, line 17, and then the language that Ms. Backus mentioned on 3.28 and 3.29. If you leave that immunity language in there, the liability for the railroad is kind of meaningless because it is an absolute, well, it's a very high immunity standard, not only for the employee, but for the employer. And it makes the reference on 3.33 relative to employee indemnification from their employer meaningless. And so those just is a cleanup. We went till 1 o'clock in Senate Judiciary last night. We didn't get to it, but I think they're going to take that language in the other body as well, and that makes the bill something that I think can all support. Happy to
And-
answer questions.
Yeah, and it did sound like there is consensus on removing that section. It's my committee and I'm the chair, so I'm going to make an oral amendment. Just to be clear, are we talking about, can you give me the line numbers? Is it all of subdivision 9?
No, Madam Chair, and excuse me. I'll wait to be called.
Yep. All right, Mr. Carlson or Ms. Backus?
Madam Chair, brief oral amendment on line 2.17. I would put "and" before powers and privileges and delete immunity. So it would say, officer has all the powers and privileges of a licensed peace officer. And then on line 3.28,
Just hold on. Research, you got that? Okay, go ahead.
and then on 3.28, delete all of 3.28 after the footnote, subject to the privileges, and delete line 3.29 up to law. So it would start a railroad company employee.
Got it. Mr. Hopkins, did you get that? All right. So, Mr. Hopkins, if you can repeat that for the record, and then that will be my motion.
So, Madam Chair and members, the oral amendment would be page 2, line 17, delete the first comma and insert and delete the second comma and delete and immunities. On page 3, line 28, delete everything after liability. On page 3, line 29, delete everything before a railroad company.
Right, that was also my understanding. So that is my motion for the oral amendment. Any discussion to that amendment? Representative Scott.
Chair Becker-Finn, and I understand this is your committee, but that's a pretty substantive oral amendment, and I just want the record to reflect that, I agree with the bill. I'm not opposed to the bill, but we have a process around here, and, if things weren't moving so quickly unvetted, maybe we wouldn't be here of having to make this substantive change in committee. So that's all I have to say.
All right. When we can find agreement in committee, why not get it done? Didn't want to pass the buck to somebody else when things are going to the general register. So I think it's actually better for us to have this discussion out in the open here. So that's why I made that choice. Any discussion, further discussion to the oral amendment? All right, all those in favor, please say aye.
Aye.
Aye. Opposed? Motion prevails. All right, thank you for working on that. Any other members of the public wishing to testify on this bill? All right, we'll move on to member discussion to the underlying bill as amended. Representative Johnson.
Chair Becker-Finn, Representative Huot. I know in the past, the bills always have had the number of hours a railroad employee could work with as a peace officer in Minnesota before getting their license. I don't see that in the bill right this time. I'm just wondering how long they would have to get their license before they could actually start in the state of Minnesota.
Representative Huot.
Madam Chair, Representative Johnson, they have to follow the same pathway that you did when you were licensed. They would have to go through that. That was the biggest discussion on this whole bill, was they have to go through the same procedures, same hours, whatever it takes. So it's no different than what you had to work so hard to get to, too.
Representative Johnson.
Chair Becker-Finn, Representative White. So in other words, they have to have their license before they can actually work as a peace officer in Minnesota.
Representative Hewitt.
Madam Chair, Representative Johnson, yes.
All right. Anything further, Representative Johnson?
Yes, Chair Becker-Finn, Representative White. I'm glad we got that part of it figured out. I do still have concerns on this bill. It's my personal concerns, because this is the first time we're allowing a private entity in the state of Minnesota to be a licensed police department.
Yeah, we did fully discuss this issue in public safety. We did have a stop there previously. Any other discussion to the underlying bill? All right, closing comments, Representative Hewitt.
Thank you, Madam Chair, and thank you for the oral amendment. That cleaned it up to get it going, and we heard about this last night, so that was great that you did that for me. Thank you. Again, this has been here for years, longer than I've even been around, and I'm glad that we finally found some common ground. Representative Johnson, I hope that we can come back and visit this if there's problems in the future. Thank you, Madam Chair.
All right, with that, I will renew my motion to recommend that House File 1718 as amended be placed on the general register. All those in favor, please say aye. Aye. Opposed? Motion prevails. All right, Representative Tabke, I think you came back. All right, Representative Tabke, I will move to refer House File 4104 to the Ways and Means Committee. Welcome to Judiciary. Please tell us about your bill.
Thank you very much, Chair Becker-Finn and members, and thank you for your flexibility on getting me on the schedule. House File 4104 is a bill from the Minnesota Auto Dealers Association. There has been in DVS a reinterpretation of language, and that language reinterpretation will cause significant delays in when anyone wants to lease a vehicle. So it will cause between weeks and months of delays, and we need to share data in order to make sure that those leases are handled appropriately. And so that's what this data sharing does.
All right, I've got Scott Lambert signed up. Or are you just here for questions?
Just here for questions,
Got
Chair.
it. Even better. Any members of the public wishing to testify on this bill? All right, moving on to member discussion. Member discussion to House File 4104. You told me it was boring, and you were right.
Happy to be boring.
Closing comments, Representative Tabke.
Thank you very much for your support, everyone. I appreciate it.
All right. I will renew my motion to refer House File 4104 to the Ways and Means Committee. All those in favor, please say aye. Aye. Opposed? Motion prevails. Thank you, Representative Tabke.
Thank you, Chair and members.
Representative Liebling. All right. I will move to recommend that House File 3443 be placed on the general register. Whoever's alarm is going off, if you can. Okay. That was the alarm for those of you who don't have Apple phones. That's the alarm when you've lost your phone and you're making it ding to try to find it. Usually I hear it somewhere in the car and I know I can head out, but that's what that was about, so. I will move to recommend House File 3443 be placed on the general register. We do have an A2 technical amendment that I understand. Representative Liebling, if you can real quick. just tell
Yeah,
us
thank
what
you,
it
Madam Chair. It lines it up with the Senate, and it is truly a technical amendment.
All right, I will move the A2 amendment. All those in favor, please say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Representative Liebling, please tell us about your bill as amended.
Thank you very much, Madam Chair and members. So I think you're probably all familiar with the Minnesota Health Records Act that's been around since 2007 that protects the privacy of patient medical records beyond the limited protections in federal law under the law we call HIPAA. And the HIPAA specifically allows states to provide more stringent protections for our residents here in Minnesota. And that's what we have been doing as a legislature bipartisanly for quite a few years. Although the MHRA has been controversial at times, it's been amended over the years, but there has been solid bipartisan agreement that the medical records of Minnesotans should not be shared without consent. Unfortunately, in October of 2023, the Minnesota Supreme Court held that the MHRA allows the sharing of medical records without consent for the purpose of fundraising. And I think we've distributed this case to you. It's Schneider versus Children's Healthcare. The court's decision in that case rests on statutory interpretation. So basically, the court didn't think we meant it, and said that where the MHRA protects the disclosure of protected health information without, quote, specific authorization in law, that the legislature meant to include federal law, including HIPAA itself. So this interpretation essentially guts the MHRA. It essentially says that anything that is prohibited under the MHRA, just look to HIPAA. Well, the very purpose of the MHRA is to give more stringent protection than HIPAA. So what this bill does, it's a very simple bill. It simply clarifies our intent that the MHRA is stronger than HIPAA, and that where it says authorization law, we mean Minnesota law, not HIPAA. The bill does not change the MHRA. I just want to be really clear about that. It merely restores the law to what it was before the Schneider case. So we do acknowledge that members may have varying views about the MHRA, what it should cover, how it should apply. We've discussed these things over the years. I'm sure we'll continue to discuss it. The bill does not take any position on any of that. I think legislators should be united in stopping the gutting of our bipartisan law that protects the medical privacy of Minnesotans. So I would ask for your support.
All right. Are there any members of the public wishing to testify on this bill? All right, not seeing any. We'll move on to member discussion. Representative Scott.
Chair Becker-Finn, thank you, Representative Liebling, for bringing this really important clarifying bill. As if I really didn't get the court's ruling. It didn't seem to me that it needed much clarification, but we'll belt and suspenders it up. And thank you for bringing this bill and protecting the health records of Minnesotans. That's what we all need to be concerned about. Thanks.
Yep. Any further discussion? Representative Liebling, closing comments.
Thank you very much for hearing the bill.
All right. With that, I will renew my motion to recommend that House File 3443 as amended be placed on the general register. All those in favor, please say aye. Aye. Opposed? Motion prevails. Thank you, Representative Liebling. Next up, Representative Klevorn. I will move to re-refer House File 4854 to the State and Local Government Policy and Finance Committee. And then I understand you do have an amendment. You want to take care of that first?
Yes, thank you, the A24.
All right, I've got the A24-0250 amendment. If you want to tell us briefly what that does.
Judge Starr, do you want to, this answers a question for your committee members, I believe.
Good, if you could introduce yourself.
Madam Chair, I'm Jenny Starr. I'm the Chief Administrative Law Judge at the Office of Administrative Hearings, and the amendment deletes lines 2.1 through 2.2, the phrase, "and any other documents or data designated."
All right, any discussion to the amendment? All those in favor, please say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Representative Klevorn, please tell us about your bill as amended.
Thank you. The courts include the Office of Administrative Hearings, the tax courts, and the Workers' Compensation Court of Appeals. The proposed language brings important changes to the executive branch courts and the data practice laws that apply to their work into conformity with the judicial branch. One, they protect judicial work product. They protect, I think those are the lines we just took out, right? No, those are, okay. They protect the judicial work product. They protect health records and allowing the courts to refer to otherwise protected data or documents when necessary in writing their court orders. That's a basic high-level summary of the bill, and Chief Judge Starr is here with me, as well as General Counsel, if there are questions or concerns.
All right. Any members of the public wishing to testify on this bill? All right, we will move on to member discussion. Representative Scott.
Madam Chair, thank you. And I'm just wondering if Judge Starr could elaborate on the issues that you're facing that is behind this bill, why the need for it, because I want to get that on the record to be for sure.
Yep. Chief Judge Starr.
Madam Chair, Representative Scott, the first issue that the executive branch courts face is that our judicial work product is currently not protected under the data practices laws. And so what that means is when I'm hearing a case and I'm taking notes for myself, or when I'm revising a decision that I'm making, currently, if those notes are still in my file at the time of a data practices request, they would not be protected. In the judicial branch, for as long as I could ever know, that kind of internal thinking of a judge is properly and appropriately protected. The matter of public record is the decision, the order itself. With regard to health records, there are times in which a person offers their own health records into a matter. They are appropriately received by the court. Portions might be referred to in a judge's decision-making, factual findings, or application of law, but largely those health records are not necessary, though they remain in the file. I hope that makes sense. What we're asking for here is, again, conformity with the judicial branch, so that if that file were to be asked for in a data practices request, the recipient would receive those factual findings that were appropriately necessary to understand the judge's decision, but not the totality of the medical records of that particular individual. And then the third portion is just clarifying that, in fact, judges, as they do today, can refer to not public data to the extent it's necessary for the public to understand the adjudicatory decision they've made.
Great. Any follow-up, Representative Scott?
Madam Chair, just know I appreciate sitting down with the judge and understanding what their needs were, and I support this. Thanks.
Yeah, glad you're advocating for yourselves. I think this is good policy as well. Closing comments, Representative Klevorn.
Thank you, Chair Becker-Fenn and the committee, and I'd also like to thank Representative Scott for reaching out in advance. It makes it so much easier. It's a great bill. We ask for your support, and I would love a unanimous vote. Thank you.
I don't think anyone keeps that stat. Maybe you do.
Just maybe I do in my head.
I will renew my motion to re-refer House File 4854 as amended to the State and Local Government Policy and Finance Committee. All those in favor, please say aye. Aye. Opposed? You did it. Congratulations.
Thank you so much.
Motion prevails. Reading next. All right, do we got Representative Norris here? Yay. When people sit in the front row, I can't see through members to know if they're here. Representative Norris, welcome to the committee. I will move to recommend House File 4347 be placed on the general register. Please tell us about your bill.
Thank you, Chair Becker-Finn and members of the committee. It's great to be with you. This bill does some cleanup on an important law that we passed last year related to coerced debt. 95% of abusive relationships involve some form of financial abuse. The law that we passed last year is designed to protect the survivors of this financial abuse while helping creditors attempt to recover the coerced debt from the perpetrator of the abuse. So coerced debt includes situations like the following. It might be an abuser stealing a survivor's identity and using it to incur debt. It could be forcing a survivor to take on debt through the threat of force, intimidation, undue influence, deception, coercion, fraud. Or it could be causing a survivor to go into debt by, for instance, prohibiting them from working. The victims in these situations may be victims of domestic abuse, harassment, or sex or labor trafficking. So this bill allows a survivor to seek equitable relief to either prohibit a creditor from holding or attempting to hold the debtor liable for the coerced debt, or dismissing any cause of action brought by a creditor to enforce or collect the coerced debt from the debtor. So this is the work that we did last year, and then this bill, Mr. Elwood, as he does so excellently, has worked with the stakeholders to work through some of the other things that have come up since we passed this law, and I'll turn it over to him to talk a little bit more about what specifically is in the bill.
All right, Mr. Elwood, please introduce yourself for the record and then proceed.
Thank you, Madam Chair, members. Ron Elwood with Legal Aid. We have, after the bill was passed, the Minnesota Bankers Association came forward and had some technical changes and a few substantive changes that would clarify what we were trying to do last year. We worked with them over the interim, as well with the Minnesota Credit Union Network, which you have a letter in your packet of support from the MNCUN. And this bill takes care of a couple of the concerns that the Minnesota Bankers Association had. I would specifically, I think one of the more important provisions is on lines 227 to 22 or 3.2, which clarifies that the debt that is relieved from the victim survivor can be transferred over to the abuser where it belongs. I'm happy to answer any questions. Appreciate your support.
All right, are there other members of the public wishing to testify on this bill? All right, we'll move on to member discussion. Representative Johnson.
Chair Becker-Finn, Representative Norris, I understand why this is needed, but I'm just curious. This bill doesn't take effect till January 1st of 2025. Normally, something like this would take first August 1st. I'm just wondering why you're waiting an extra 4 or 5 months.
Mr. Elwood.
Madam Chair and Representative Johnson, this is the request of the Bankers Association to allow them to prepare their members for some of the changes, and we acceded to their request.
Any further discussion? All right, closing comments, Representative Norris.
Chair Becker-Finn and members, I just appreciate your continued support for supporting the survivors of this coerced debt situation.
All right. With that, I will renew my motion to recommend that House File 4347 be placed on the general register. All those in favor, please say aye. Aye. Opposed? Motion prevails. Thank you.
Thank you.
Representative Hansen. I will move to re-refer House File 44, I just think about animals. House File 4410 back to the Environment and Natural Resources Finance and Policy Committee. Welcome to the committee, Representative Hansen. Please tell us about your bill.
Thank you, Madam Chair. This is an agency bill with a couple of small changes. So I do have the Minnesota Pollution Control Agency staff here to walk through the bill.
All right. Welcome to the committee. Please introduce yourself and go ahead.
Thank you, Madam Chair and members. For the record, my name is Tom Johnson, Government Relations Director for the Minnesota Pollution Control Agency. I want to thank Chair Hansen for bringing this bill forward. It is an agency bill. As Chair Hansen mentioned, there have been some amendments, and I'll talk a little bit about those in a second, but largely this bill is brought forward by the agency and makes some clarifications regarding the agency's enforcement powers, and then also creates some new tools in our emergency powers section. So some examples of what we're looking at here on line 2.1, the committee will see the agency has the ability to already to adopt, reissue, modify, deny, reopen, et cetera, permits and also enforcement documents related to preventing and controlling water pollution, but we're adding that term reopen to create some clarity there. We're also creating some areas where we feel that there is already an intent in statute, but that's not clear in existing law. We are creating those sections like in Section 6 and Section 9. This is clarifying that if an entity were to have been required to get a permit and failed to get that permit, they are still subject to those same requirements that would be in the permit that they failed to obtain. So just ensuring that there's no incentive for an entity not to get a permit over another entity that is complying with the law and obtaining their permit as required. And then the final section, Madam Chair, to just point out is this Section 10, Emergency Powers. And this is addressing, the agency does already have emergency powers, but it requires that the agency approve imminent and substantial endangerment. And that is a very high bar that is very difficult to prove. And there are various situations that the agency has encountered where there is still acts of significant concern to the public health and environment that the agency would like to take more drastic action to ensure the public safety. And these are listed in subdivision 2, line 10.6 to the end of the bill. Really 10.8 to 10.12 is that those areas where we may exist this or exercise this additional authority would be only in cases of falsification of records, history of noncompliance with enforcement documents, chronic or substantial permit violations, or operating with or without a permit where there is evidence of danger to the health or welfare of the people of the state or evidence of environmental harm. So there are some additional actions that the agency can undertake, can take under those very emergency situations, and we feel that those are appropriate for that type of evidence of additional harm to the state or its people. So would ask your support on the bill as total. I will note, again, there were some amendments to this language. You'll see most of them in the Environment Committee were technical changes that the agency supports. However, on lines 7.13 and then 7.18 to 7.19, you'll see the addition of here of or any person on 7.13. And then again, or any person on 7.18, 7.19. These would create the ability for any person to take action on behalf of the state. And we have some concerns with that language. There's already a federal process under the Clean Water Act, the Clean Air Act, and the Resource Conservation and Recovery Act, or RCRA. And that process already exists in federal law and is for any person, against any person. So there's already a process available for injured persons. So I ask your support of the bill, and happy to stand for questions.
All right, we do have one public testifier signed up, Tony Quillis. And then are there any other members of the public wishing to testify on this bill?
morning, Madam Chair and members of the committee.
Welcome to the committee. Please introduce yourself and go ahead.
My name is Tony Quillis, and I'm the Director of Environmental Policy at the Minnesota Chamber of Commerce. I want to thank you and the members for allowing me to make a couple of comments on House File 4410. Madam Chair, I want to come at this from a perspective of a permit holder, and it's statewide for all the permits that the Pollution Control Agency issues, including air, water, and hazardous waste. This won't affect only businesses in the state, but also cities and counties. The first section I'd like to draw your attention to is on 4.15, and it shows up again on 8.28. And it talks about negotiated agreements where the agency is able to go in on costs over $25,000 and start accumulating expenses for modeling, risk management, sampling, and monitoring. There is no appeal or no way for a permittee to recourse or challenge any of these expenses. And so I think, Madam Chair, that's going to lead to increased litigation, which is more time and cost to the agency as well as permittees. Second concern is also, as Mr. Johnson pointed out, allowing any individual to bring civil penalties against permittees. I think it also leads to confusion besides being covered in federal law. If an individual, as well as the Attorney General, brings action against the permittee, how those damages would be divided up. Sections 2 and 4, Madam Chair, deal with increased ability of the agency to cease operations. I think those are duplicative because they are covered under the emergency powers of the agency under Section 10, where they have the ability to immediate discontinuance of abatement of pollution without notice and without hearing. And I don't know of any case where they've been denied of this authority. And then finally, Madam Chair, in Section 10, also in Subdivision 2, the noncompliance and chronic and substantial are very broad, and I think that they should be further defined because it leads into suspended and revoked permits for the agency. So, Madam Chair, thank you for the ability to make my comments on House File 410.
All right, thank you. Come on up. Please introduce yourself and proceed. And as the testifiers who signed up ahead of time, you'll be given 2 minutes.
Thank you so much, Madam Chair, members of the committee. My name is Joy Anderson, and I am an attorney at Minnesota Center for Environmental Advocacy. I am testifying in favor of this bill, including the private right of action, and against the amendment that has proposed stripping out that private right of action. This bill is important because it clarifies MPCA's authority, and it ensures that MPCA is empowered when people are violating their permits, not just to talk sternly to them, but actually to shut them down until there is no threat to human health or permit violations. And it also provides a private right of action in the name of the state to enforce those violations. And it's important to keep both of those things in there. The worries about the broadness of this private right of action we do not believe are warranted. The penalties and damages, it's very clear if you look at the language, they only go to the state. There are no private damages to the person who brings the action. The penalties go to the state. If there's damages for the environmental harm that's caused, those go to the state. And there are no attorney's fees that are recoverable by the private person. So the only person that's going to bring an action under this is someone who is really motivated to stop pollution that's happening in their community. They don't get money. They don't get attorney's fees. There's nothing there. That makes it less broad than the private rights of action under 8.31 that we were talking about today, and even under the federal statutes that were referred to earlier by MPCA. And it is important, despite those federal rights of action, to have this state right of action because there are state permits that don't have these federal protections. We think it's really important to ensure that MPCA really clearly has this power to shut down operations that are polluting, and that private citizens, when MPCA can't get to everything, because MPCA can't, they have a limited amount of enforcement that they can do. Private citizens should be able to say, this thing is right next to me. It's polluting on my property. I need to get it shut down until this is fixed. Thank you so much.
Thank you for your testimony. With that, we'll move on to, we do have an amendment. Representative Niska, I believe it's your amendment. If you want to move the A5 and then tell us about your amendment.
Thank you, Madam Chair. I do move the A5 amendment. I think that, that it's pretty clear from the discussion that the issues we're talking about here are issues that are statewide issues. They're public enforcement issues, and it's important, I think, that that issues like this are enforced by actors that are politically accountable to the public of the state. And that means, in this case, the MPCA. I did appreciate the testimony from Mr. Johnson from the MPCA. And I would like to also refer back to a conversation we had about a similar public interest regulation issue last week in the social media enforcement bill. Representative Stevenson pointed out, again, I think, and this is, I think, a really important thing for us to think about in this context, that bad cases make bad law, and the experts at the MPCA have particularly the expertise and the flexibility to look at particular cases and how to bring that litigation in a way that's not going to, create potentially bad rulings and adverse consequences. So I do think it's important that we vest this enforcement authority with the MPCA and with the Attorney General. This language follows the same model as the amendment I offered on the social media bill that was taken by this committee, and that Chair Becker-Finn, you said we should make good amendments. So I'm trying to make another one here. So I think that this is reducing or a more efficient way, a more effective way to enforce these provisions without a lot of stuff going into the court system that maybe can be handled in a better way by the MPCA or the Attorney General. So I urge members' support. Thanks.
All right. Representative Hansen.
Thank you, Madam Chair, and Representative Niska. Although I appreciate your strong support of the Chevron deference for agencies, I have to oppose your amendment. I think it's important with as was testified both by the agency and by one of the testifiers, this is similar to what we have in federal law, but Minnesotans should have that opportunity under Minnesota law. Just kind of simply why. So what the amendment does is takes that away, and I would oppose the amendment and ask for opposition.
All right. Any further discussion to the amendment? All right. Closing comments on your amendment, Representative Niska.
Thank you, Chair Becker-Finn, and appreciate those comments. Representative Hansen, I will respectfully decline the invitation to explain the difference between Chevron deference and prosecutorial
He's not even a lawyer.
But I think it's a good amendment. I hope members will support it, and I request a roll call, Madam Chair.
All right. Roll call having been requested. Representative Niska renews his motion on the A5 amendment. The clerk will take the roll.
Chair Becker-Finn.
No.
Vice Chair Frazier.
No.
Minority Leader Scott.
Aye.
Representative Carroll.
No.
Representative Curran. No. Representative Feist.
No.
Representative Finke.
No.
Representative Frederick. Representative Grossel.
Aye.
Representative Johnson.
Aye.
Representative Moeller.
No.
Representative Niska.
Yes.
Representative Weens.
Aye.
Representative Frederick. 5 ayes, 7 nays.
With 5 ayes, 7 nays, the motion does not prevail. Moving on to member discussion of the underlying bill. Representative Curran.
Thank you, Chair, and I just wanted to say thank you so much, Chair Hansen, for bringing this bill forward. I happen to represent the community that was heavily polluted by water gremlin, and we know that enforcement would have been key in preventing the damages that still continue in my community. So I truly appreciate your work on this, and it's much needed, and I know my community is looking for this. So thank you.
The community I used to represent as well, and I know there were some problems with not stopping the pollution sooner, and there was harm, definitely. So thanks for bringing that up. Further discussion to the Representative Scott.
Madam Chair, I just had a question for the MPCA, just a clarifying question on the emergency power, or the, is that right? Yeah, the emergency powers. And can the MPCA, if you could clarify, if the authorities allowed in that section apply to paper violations, or would it be limited to emissions violations?
And I'll just say, some of the testimony was to issues not before this committee that are more properly before the Environment Committee, but I will allow him to respond, but we're not going to continue. This is not precedent setting as far as going off topic. Director, go ahead.
Thank you, Madam Chair. And Representative, I would say it depends. There are some paper violations that we would consider very serious in terms of record keeping, for example, for hazardous waste. There have been major violations of a facility that was required to keep records of their hazardous waste for an incinerator that they were operating, for example, that we considered a very serious violation, one of the largest enforcement cases the state has brought in recent years. However, if you're referring to the submission of a document that the agency has requested that is somehow late, no, we would not be using this emergency powers for that type of violation.
All right. Anything else, Representative Scott? All right. Closing comments, Representative Hansen.
I'd ask for your support.
All right. I will renew my motion to refer House File 4410 back to the Environment and Natural Resources Finance and Policy Committee. All those in favor, please say aye. Aye. Opposed?
No.
Motion prevails. Representative Feist, we're going to use the 5 minutes we have. Right, Representative Feist, would you like to move to re-refer House File 4822 to the Environment and Natural Resources Finance and Policy Committee?
Yes, Madam Chair, that is my motion.
All right, and if you don't mind, I'm going to go ahead and move the A2 amendment. This is my amendment. This just was quicker for me to do it. So the A2 amendment removes Section 1 of the bill. The underlying goal of the bill is to respond to the Tyler Supreme Court decision, and I did not believe that the first section of the bill was properly in this bill. It's kind of a separate discussion as to how things should be funded. And so that is the motion to remove the Section 1 of the bill. Any discussion? Representative Feist.
I agree.
Any other discussion to the A2? All right. All those in favor, please say aye. Aye. Opposed? Motion prevails. All right. Representative Feist, please tell us about your bill.
Great, thank you. This bill is in response, as you said, to the May 2023 unanimous decision by the U.S. Supreme Court in Tyler versus Hennepin County, which found that Minnesota's tax forfeiture laws were unconstitutional. Specifically, the Supreme Court found that the county's excess proceeds from the sale of tax-forfeited land beyond the total delinquent property taxes, costs, and fees owed was a violation of the takings clause. And I believe I forgot a verb in that sentence, but it's the county's keeping of those excess proceeds was the violation of the takings clause. The bill before you is the result of extensive collaboration and dialogue among stakeholders, including the Association of Minnesota Counties, which convene counties across the state to evaluate the Tyler decision and identify solutions. Legal aid, the Judiciary branch, constitutional scholars, and the DNR, among others, have also been included in conversation and analysis. I would also like to recognize the extensive research and counsel of nonpartisan staff that they have committed to this complex challenge. House File 4822 does the following. It makes a public auction mandatory when a claim for surplus proceeds is filed in order to pay out any excess proceeds to the property owner. It also creates a process to ensure that excess proceeds on minerals are not retained in violation of the takings clause. The bill addresses the holding of Tyler while also keeping many aspects of the existing law that make Minnesota unique and responsive to property owners. Specifically, we have a long redemption period, payment plan opportunities to extend the redemption window, and ample noticing periods. Note that we are working on some updates to the language in response to additional input. That includes making the notice, the claims notice and process more clear and friendly to the property owner, providing clarifying language around scenarios involving multiple claimants, and making some additional technical changes to just facilitate a smooth process for the counties and the homeowners. Due to the Supreme Court's holding in May of 2023, we must take steps to immediately reform our tax forfeiture laws. This bill represents a balanced approach to this directive that incorporates perspectives and expertise and the hard work of many stakeholders and legislative staff. If we are not able to reform our laws, we are perpetuating a broken system for property owners and adding fiscal liability to the state. The problem will only get more expensive as time passes. And I have an expert here to say a few words, and then we also have a minerals expert if there are questions on that portion of the bill.
All right, welcome to the committee. Please introduce yourself and proceed, and I would like to get to the public testifiers before we recess, so welcome.
Thank you, Madam Chair. My name is Dan Rogan. I'm the Assistant County Administrator for Resident Services. And in the spirit of being short, Representative Feist did a great job of explaining the Tyler decision. On behalf of counties, I just want to clarify that right now the statutes are unconstitutional. We need the legislature to pass something so that we can continue to enforce Minnesota's laws in a constitutional way. And so with that, I'm happy to answer any questions about Tyler or other questions.
All right. I've got Joe Henderson. Is that your person who's available if there are questions, or is that somebody else?
I'm sorry, who did you ask?
Joe Henderson?
That is someone else that
All
I
right.
don't know.
I don't see that person here. All right. It was somebody from the DNR, so I assume it's something that can be discussed more fully in the Environment Committee. Did you need to testify?
We sought to testify, yes.
Oh, yep, when I say your name, you got to get up. All right, and then I've got Christina Martin on deck if you want to come on over. You can pull up a chair. All right, welcome to the committee. Please introduce yourself and proceed with your testimony.
Thank you, Madam Chair. Committee members, my name is Joe Henderson. I am the Director for the Lands and Minerals Division at the Minnesota DNR. The DNR did submit a letter outlining our concerns on this bill, but thank you for the opportunity to comment on the proposed bill. As mentioned earlier, the bill allows a landowner to file a claim alleging that the value of his or her property exceeds the delinquent taxes, special assessments, penalties, and interest and costs. The landowner may file the claim with the county auditor during the period of redemption. The county will then auction the property, and the landowner is entitled to the surplus proceeds of the auction. When the property is auctioned, the county transfers the mineral interest to the state of Minnesota. This provision is consistent with the requirements within the Minnesota Constitution, which requires the state to reserve mineral rights on all properties that it transfers. Under this bill, if a landowner alleges that the value of the mineral interest exceeds the delinquent taxes, special assessments, penalties, and interest and costs, the Department of Natural Resources must determine the value of the mineral interest and provide a payment to the landowner of any excess amount. The DNR has three major concerns with this bill. First, as written, the DNR commissioner must determine the value of the landowner's mineral rights if there's a claim for surplus proceeds. The claimant is not required to provide any data or proof of existence of valuable minerals for the assessment of the value. The DNR does not employ staff who work in the area of mineral evaluation. DNR would need to retain additional staff to do this work. It would take an additional attorneys, engineers, project managers, economic geologists, to manage this statewide requirement. Second, the bill seems to require an auction even for properties that have typically been withdrawn from sale. For example, under current law, tax forfeited lands within state parks, certain forfeited lands on meandering waters, and lands subject to mining permits are withdrawn from sale. The withdrawal from these parcels from sale is consistent with land uses and protects the conservation value of the lands around them. Third, because landowners could file claims challenging the DNR's mineral evaluation, the DNR estimates that we would need to reimburse the Minnesota Attorney General's office for about one attorney's billable hours per year. We must use the Attorney General's office to defend us. It also should be understood that when the DNR would pay claims relating to mineral rights, the funds to pay those claims would come from the general fund. Madam Chair, committee members, thank you for hearing the DNR's concerns.
Yep, and I encourage you to work on this before it's heard in the Environment Committee. Ms. Christina Martin, please introduce yourself and proceed.
Good morning. Thank you. My name is Christina Martin. I am a senior attorney with Pacific Legal Foundation. PLF's a nonprofit public interest organization. I represented Geraldine Tyler with PLF at the U.S. Supreme Court. I argued the case, and that's the decision and ultimately is precipitating this bill. In Ms. Tyler's case, she owed $2,300 in property taxes, and after adding penalties, interest, and fees, her debt became about $15,000. And the property sold for $40,000. There was a $25,000 windfall. The Supreme Court said this was unconstitutional to take a windfall at the expense of a debtor like Ms. Tyler. Unfortunately, the House Bill 4822 will not fix this problem.
It creates a loophole to the Supreme Court's decision in Tyler. Rather than treat Ms. Tyler just like any other type of debtor, the law would let the county debt collectors continue to take windfalls. It shifts the burden on the debt collector to return the surplus proceeds onto the property owner to proactively go forward before they've even lost their property and then say, yes, of course I want to be paid for the value of my property. That doesn't make sense. And Michigan adopted a similar bill in 2020, and the result has been overwhelmingly that people do not get their surplus proceeds. They make their claims too late. I'm representing 4 such individuals in a case out of Michigan that, like this, would have required them to claim surplus proceeds before there were any. And there's been a number of lawsuits filed across the state of Michigan. They've been riddled with lawsuits. And if this bill passes in this form, it too will attract lawsuits in Minnesota. And I would be happy to maybe get to go back to the U.S. Supreme Court with one of those cases. I just want to touch on a couple of things that are really important for you to understand.
And
I'll wrap it up.
I need to wrap up.
I'll wrap
We
it
do
up.
have your letter is in the packet.
My letter is in the packet. The vast majority of these people are not capable of figuring out the system as it is. And there's a lot of really difficult circumstances that lead to people losing their most valuable asset and their home. And so I would just encourage the committee to not just provide better notice, but to give people more time. And if you have any.
Ms. Martin, you really
Yeah.
need to wrap up. It's not fair to the other testifiers, so I
Sure.
cut off at 2 minutes to allow anyone to go further than
Thank
that.
you.
So thank you for your testimony. With that, members, we're going to recess, so we have time to discuss when we come back this evening. Members, if the bills that we didn't get to and 4822, if you can put things back in your folders to make it easier on staff, and so you have those available this evening, that would be great. All right, with that, we're in recess.